So I want to welcome everybody to tonight's Salt Talks. As you know, this month we were working on planning for when I am gone. It's usually not a matter of if, it's a matter of when, and we need to prepare for that time frame. Um, Things happen unexpectedly, and it's always good to just be prepared. So that's what our focus was on all this month. So tonight we are looking at planning for when I'm gone, how to build your legacy. I brought Shane Krugler. He's spoken a few times over the course of the years during SALT, and then I thought it was a good time to bring him back and to talk a little bit about this topic. So I am going to turn it over to Shane, and I want to thank you for coming tonight.
Hi, thank you, Patty. I appreciate you inviting me. It's nice to see you again. So, welcome everybody. Again, thanks for attending today. My name is Shane Krugler with Krugler Law. We are an estate planning, elder law, and probate only firm. So, we deal a lot with last wills, testaments, last will and testaments, probate, trusts, and a lot of elder law issues as well as obviously special needs. So, today, I know initially when I talked to Patty, we were hoping that we could use some of my old friends' documents as it relates to really documenting everything to where if you were to ever pass away unexpectedly or if you were expecting to, people would know exactly what they need to do. And unfortunately, my friend passed away a few years ago, and I'm still working with his estate and his wife to get rights to those documents. So, Patty, I would say as a secondary issue, as a follow-up today, I can probably get some access to those documents and you can share them, even though it won't be part of tonight's presentation, because I think they are very helpful. Okay, wonderful.
That would be
Uh,
great.
so,
Thank you.
Absolutely. Okay, so just to kind of give everyone a little bit of background on me and our practice, I got started in estate planning approximately, it's been almost 10 years ago. I worked in compliance and ethics for banks and insurance companies as a chief compliance officer, and then my father-in-law was diagnosed with brain cancer. And during that time, I learned about all the things that we're going to be talking about today because unfortunately, we did not have anything in place when he got sick. He ended up moving in with us and was paralyzed. And my mother-in-law had MS, so we had our hands full with three young children. And we found that it was quite a nightmare trying to navigate not only the legal aspects, but the medical aspects as well, and understanding Medicare and the benefits that he was and was not receiving at the time. So, because it was so affecting my family, I actually quit my banking job and started a law practice at home while I was taking care of him. And as I was talking to Patty here in the beginning, from those origins to this point now, we typically have two attorneys. We'll have three as of May. We're expecting to open our second office in Harrison, Ohio, here within the next 2 months. We do, again, estate planning, elder law, probate. We have a full-time social worker that helps our clients on an ongoing basis with medical issues, elder law issues, special needs issues, as well as a few paralegals and an admin. So that's our office. We are located currently in Delhi, if you know where that's at. It's on the southwest side of Cincinnati, just about 15 minutes south or southwest of downtown, essentially, right on the river. Moving forward here. Here's some of our team members here. My wife is actually my paralegal. She was a litigation paralegal long before I ever became a lawyer. That's the blonde there on the right. Uh, right below her is Hillary Rabel. She is our probate paralegal who does almost all of our probate work. Liz is on the bottom left. She's our legal office administrator and basically is the voice on the phone every time you call our office. And finally, we have on the bottom right-hand side is Allison LaCalametto, and she is our social worker. So that's our staff as of moment again, or at the moment. We'll be adding two more attorneys in May who primarily focus on estate planning and probate. So we already talked about what we offer, so we'll skip over that. When we talk about estate planning, we really put it into three phases. The first phase and the most important phase is what do we do to make sure that everything is taken care of while you're here and healthy. That's always the best time to put these documents in place. A lot of our clients call and ask, when is the best time to start thinking about estate planning? And quite honestly, it's 18 years or older, and if you have someone that's relying on you, it can be earlier than that. Obviously, when you have family members with special needs and other issues, then the earlier the planning, the better. The second life phase is if you become sick or incapacitated. Hopefully, by that time, we have all of our documents in place necessary to navigate that portion of our life. And finally, estate planning is also about how we handle your assets after you've passed away. All right. So, what does a proper plan do for you specifically? First and foremost, it prevents court control. We're going to talk about some documents today to where if you don't have them in place before something happens, you could get thrust into something called a guardianship. In the state of Ohio, a guardianship is broken into two types. You have guardianship of the person and you have guardianship of the estate. The guardianship of the person is basically who's there to make your care decisions, who's there to care for you on an ongoing basis. This is what you think about typically when you name guardians in your last will and testament, or if you have an older parent who can no longer make their own decisions due to incapacity, such as dementia, then that's where we're going to court and getting the right to make those decisions. The other type of guardianship is something called guardianship of the estate, and that's there to determine who's going to manage essentially your financial and legal decisions. So by having these documents in place, we can avoid those issues. Additionally, if you pass away and you don't have a plan in place, unfortunately, your assets could potentially end up in probate court, which we'll talk about today. And it's really avoiding, as that says in the beginning, court control and really court influence on doc or on any type of decisions that you're making from a healthcare, legal, or financial perspective during your lifetime and thereafter. Next, an estate plan, a proper estate plan will help you from having assets go to the wrong place, even by accident. We'll talk a little bit more about that, but even if you don't have an estate plan, those documents will be, or those documents, excuse me, those assets could be passed on to family members based on state laws, which we'll discuss a little bit later. And then finally, an estate plan will help you protect your savings and potential benefits from being lost to creditors, long-term care costs, or other risks. So today, what we're going to do is we're really going to walk through how to avoid all these potential issues with the documents that we can put in place. By the way, if I start to talk too fast, Patty, just let me know. We do have a lot of information to cover, so I like to get through it. And just as a precursor for everyone, even though I do have a tendency to talk quickly, know that this is really just an education to help you issue spot. I'm not expecting you to get off of this call today and be an expert. We're really hoping that there's some things that ring true to you today that goes, okay, this is something that I need to follow up on. So we are going to talk about quite a bit, and it can be a little in-depth. So I will try to slow down when it's very, very important to do so and have a natural rhythm, but at the same time, just know that this is really about helping you understand how to identify issues on your side. So, what are the core elements of a solid estate plan? Here are the documents kind of laid out for you before we even start discussing them. First and foremost, and usually the most important documents that any of my clients deal with, whether they're 18 years old or 98 years old, is financial and healthcare powers of attorney. That's a document that allows someone else to step in and make your healthcare and your financial decisions. Again, we're going to talk about these in a little more depth. Next is a living will, is a document that says if you're making the decision now that if you ever become permanently incapacitated in the future, where you have no cognition and you're to the point that you're essentially on a ventilator or IVs, feeding tubes, and you have no chance of regaining consciousness, this document allows you to elect to be removed from life support sometime in the future. A HIPAA authorization is simply the release of your medical information to whoever you've named. Going to that third picture there is beneficiary designations and proper asset titling. Essentially, if and when you pass away, we want to make sure that everything that you have is passing on to your family in a way that avoids probate and court intervention. The fourth one is trust planning, which there's a lot of great reasons to have trust. Not everybody needs them. So we'll talk about when these different types of trusts are applicable and how to utilize them. And then finally, we are going to talk about long-term care planning and asset protection strategies. All right. So, as we kind of talked about earlier, the most important documents to focus on whenever my clients call, they almost always say, how much is a last will and testament? And to that, I always say, come in for a free consultation and we'll help explain things for you before we quote prices because most people don't necessarily need a last will and testament. And quite honestly, making sure that you're taken care of during your lifetime is so much more important than what happens to your money after you pass. So a comprehensive estate plan is really primarily and first and foremost focusing on you during your lifetime. There's a little picture there that I like to use that's a picture of a flight attendant. As we all know, when that mask drops down, when oxygen or pressure levels change, what's the expectation? That you put the mask on yourself before you put it on the people around you. Your estate plan basically works the same way. If you have other people that are relying on you, we want to make sure that you have the documents in place that if you become incapacitated or unavailable, we know that you're covered as well. And then those people are obviously able to help you care for others. Just some quick notes here as from statistics. For our clients that are dealing with dementia or other declines where they're the caregiver, 60% of caregivers actually pass away before the people that they're caring for just because of the stress associated with being a caregiver. So having these documents in place, even for yourself when you're caring for someone else, is very important. So, what are those documents? As we talked about before, there's something called a durable power of attorney that handles, again, the financial and legal decisions. If you're not able to make them yourself, you're nominating someone else to do so. You have something called a healthcare power of attorney, which is for medical decisions. You have HIPAA authorizations, which is the release of medical information, and we have your living will. So, what I'd like to do now is jump into a particular scenario and talk more about that durable power of attorney. So, let's assume that your client's mother suffers from rapidly developing dementia. Eventually, she loses legal capacity, meaning she no longer understands the decisions that she's making legally, and she's no longer able to make those decisions. She would therefore have no right to personally name loved ones to assist her legally or financially. Since she's no longer able to put these documents in place, we're stuck with those guardianships of the estate and the person that we talked about earlier. So, out of all the documents that we're talking about today, this durable power of attorney is by far the most important document that affects all of my clients all the time. If you do not have this document in place and you become incapacitated and you're unable to make these decisions, or your loved ones are unable to make these decisions, there is no other option other than guardianship. So someone would have to step up, go to court to kind of give you an idea of what that looks like when you're forced to go into guardianship. It usually takes about $2,500 of investment with a lawyer in the court to get that process started. And then every time you need to utilize the money, you're requesting it from the court. You have to do ongoing accounting on an annual basis, sometimes every 2 years, and it's a bit of a nightmare. So simply having this document in place allows us to avoid court intervention. Okay, as part of that process, the other thing that I wanted to mention here is that not all powers of attorney are created equally. There is a statutory form out there that you can get free online that gives you some basic rights, but what people don't realize is that these powers of attorney, unless you've specifically handwritten it into these documents, they don't have the ability for you as the person serving as the POA, also called an attorney in fact, to change beneficiary designations or even to add beneficiary designations on that person's account. So if you are the POA for a loved one and they are sick later on, a lot of my clients come to me and say, Mom is in long-term care, she had a stroke, whatever the issue may be. We want to make sure that all of her assets don't end up in probate court, and we need to name beneficiaries with banks and other places, which we'll talk about a little bit later. You typically do not have the ability to do that with the standard statutory form. So I highly recommend if there's any documents that you're going to talk to a lawyer about tonight, this is probably one of the most important ones to make sure that whatever document's being drafted for you is going to meet your loved one's needs. All right. Moving on. Uh, what I'd like to talk about now is permanent incapacity. Before I go there, let me jump into the situation related to the healthcare power of attorney. The reason that I didn't put so much emphasis on that particular document is because state law already says that if you're a married couple, your spouse can step in and make your healthcare decisions, even if you don't have documents in place, unlike the financial power of attorney. Then the law says if you're not married, then it becomes the next of kin's decision to be able to make those healthcare decisions. So if you have multiple children, all of your children have the right to step in and make your healthcare decisions. If they disagree, then back to probate court we go, where a judge is the one making the decisions on who's going to be making those long-term healthcare decisions for you. So we highly recommend that you have this healthcare power of attorney. Not only are you naming people in particular order so that there's not confusion later, but by having an updated document, you are identifying the person's name, their address, their phone number, and keeping that on file with your healthcare provider so that something ever does happen, they know exactly who to reach out to so that we can really continue care as quickly as possible. Going into HIPAA, which I'm sorry, going into your living will, which is the one we have up here. For some of my older clients here on the line, you may have heard of the name Terry Schiavo. This is a woman who was a mother in 1990 who had issues with an eating disorder, ended up becoming bulimic, and as part of that process, she had a heart attack and lost oxygen to her brain. At that time, she was permanently incapacitated. Her husband wanted to remove her from life support because the doctor said that she would never regain consciousness. Her parents, who were very religious, felt that it wasn't appropriate and that she would eventually come out of that situation. And unfortunately, it went through 15 years and 15 court hearings before they finally granted the husband the right to remove her from life support. So this is just a real life scenario where having that living will or advance directive in place is very, very helpful. When I started doing this when my father-in-law got sick, I used to think that this document was really about the person who's signing it. In reality, this document is honestly about the people who don't have to make that decision for their loved one, knowing that the loved one had made the decision prior to any type of incapacity. All right. And then HIPAA, real quick, HIPAA is just the release of your medical information. With that document, what people don't necessarily realize is you may have a HIPAA form on file at your primary care provider now, so whether that be Children's or Christ or wherever, that HIPAA form is only good at the hospital where you have completed the form. Under federal law, you are required to authorize a specific hospital to release that information. So if you end up going and getting into a car accident in Florida where you're not able to sign that HIPAA form at whatever Florida hospital you're at, we provide a universal HIPAA form that basically has a blank line in it that allows your loved one to actually write the name of the hospital right in that authorization form, and then they'd have access to the information no matter where you're at. So again, there's some limitations with some of the forms that are out there online. So just make sure you read through them and truly understand how they work if you're doing this on your own. And then with that, Patty, this is kind of that first bucket that we were talking about the documents that take care of you. So I will take a pause for just a moment just to make sure I didn't miss any questions or allow someone to ask anything before we jump on to some other areas.
So far, no questions.
Okay, easy enough. All right. So next, when I talk about estate planning, we usually put it into three buckets total. The first bucket is what do we do to make sure that you're taken care of during your lifetime, which is what we just talked about with those four different documents. The second bucket is what do we do with your assets if you do pass away? So let's talk about that for a few minutes because I think it's very important to understand how we do this planning properly. So let's see. Let me just take a quick look and see what we have here. Okay. I think this is probably the best place to start. So imagine that your loved one passes away. There are laws in place right now that deals with how those assets pass on to loved ones. So what the law says first and foremost, before any last will and testaments were to come into place or anything else, the law says if you have an account where you are a joint owner, so if you are on a joint account with a child or a parent or a spouse, and that person passes away, that asset automatically goes to that joint owner. And the way that that works in reality is it usually takes about 7 days to get a death certificate from a funeral home. Once that funeral home is presented to the custodian of that asset, which is simply the person managing that asset, so it would be the bank or the investment company. If it's a car, that would be the BMV. If it's a house, that would be the recorder's office in that particular county. But you present the death certificate to that custodian, and they will release that asset automatically to the joint owner. A little bit of paperwork involved, but usually you can have assets transferred to joint owners in a matter of a few days or less. So that is the first thing that the law says. If someone passes away, did they have a joint owner? If so, pass it directly to the joint owner. No last will and testaments, no court. Then the law says, okay, if you passed away and you did not name a joint owner, did you name a beneficiary? And then in the state of Ohio, we're very lucky because you can name beneficiaries on every type of titled asset that there is. So again, bank accounts, cars, houses, insurance policies, you name it. If it's a titled asset, meaning your name is on it somewhere showing that you are an owner, then you can name a beneficiary. There are two types of beneficiary designations that I'd like you to know about. One is something called a POD, which is simply means payable on death. It's a liquid asset like a bank account that says when this person passes away, you can pay out the money in that account directly to whoever you've named as the beneficiary. The second type of beneficiary designation is something called a TOD, and that is transferable on death. And that's usually a tangible asset like a house or a car. So we have clients that come into our office expecting to spend a ton of money on an estate plan and have a trust and all these things that we're going to talk about later, where in reality they realize sometimes just having beneficiary designations on all their assets are simple enough. And you can name beneficiaries on your assets, again, completely free just by reaching out to the custodians of those assets. The only thing that typically requires a little bit of legal intervention through a lawyer or a title company is something called a transfer on death designation affidavit, or a TOD for your house for short. That requires a deed description and it gets filed with recorder's office, which takes a little bit of expertise. So most lawyers will do those for you at a small fee of a couple $100s, and you can have that in place. Okay, so then the law says if you did not name a joint owner and you did not name a beneficiary, then, and you didn't have a trust, which we'll talk about a little bit later, then you passed away without telling anyone where you wanted your assets to go. And then when that happens, unfortunately, what your loved one or whoever is trying to get access to those funds have to do is they have to sue you. Excuse me. This is what many people refer to as an estate or through probate. So when you don't name a person, say your loved ones, your children come to your house and they go, okay, mom and dad passed away. What are we going to do now? They go through that same exercise. Did we have joint owners? No. Were we beneficiaries? No. Well, now we're stuck with these accounts or this house or these cars, and we don't know what we need to do with them. So they have to sue you after you've passed away through the probate court. And when we have to use that, that is when a last will and testament comes into place, and only when a last will and testament comes into place. And that last will and testament is simply introduced as evidence in that lawsuit to prove where you wanted that asset to go. One of our primary expectations for all of our clients going or coming to our office is really making sure that we never have to use a last will and testament, because if we do, that means we're stuck in court. If we're stuck in court, that means your family's going to pay a lot for a lawyer. It usually costs 5%, around 5%, to have a lawyer represent you through the probate court. So if you have a $200,000 house, you're probably paying a lawyer $10,000 just to move it through the process to give it to your family when you could have done a TOD on that house for a couple $100s while you were alive. So one, it's expensive. Two, it's time consuming. Under Ohio law, in all counties, if you pass away, creditors actually have a right to make a claim against your estate before anyone else. So even if you were to pass away tomorrow and your husband or wife comes to me the next day and says, "Hey, I need access to all these bank accounts because there was no TOD or joint ownership," then I say, unfortunately, it's got to stay in the probate estate for a minimum of 6 months to allow creditors to make a claim. So first you pay the court, which is cheap actually, it's about $300. Then you pay the lawyer, which is not so cheap, about 5%. Then you pay creditors. And then after all those people are paid and 6 months have gone by, then we can pay out the beneficiaries. Here's a little bit of a life hack for you. If you have this situation where we have assets that have to go through probate court, know that you don't have to open up the estate immediately through the court. If you wait 6 months and one day before we open up that probate estate, we do not have to pay creditors back because there's a statute of limitations essentially in the state of Ohio that says creditors have to make a claim against your estate within 6 months or they do not get paid back, or at least you don't have to pay them back. So if you have unpaid credit card bills, which I once saved a client $120,000 in credit card debt when they passed away, simply by waiting 6 months and one day. If you have long-term care costs or other expenses, those will not have to be paid back if we wait that 6 months. The interesting thing to know also is creditors have just as much right to open up the estate as family members. However, we've never seen them do that. Also know that if we're dealing with Medicaid, that's a whole different ballgame where they can collect. If you have secured assets like a house note or a car note, please know that those don't go away. So really, I'm talking about unsecured debts and non-government benefits, essentially, that would not have to be paid back, which quite honestly is the majority of everything that would have to go through the probate court anyway from a debt perspective. Okay, so um, I think that's the last piece on probate. Outside of it is a public process. So if you go out to, excuse me, if you go out to Hamilton County Probate Court's website right now, you can look up every last will and testament that's ever been entered through the court. You can see their entire estate, how much money they had, all the different bank accounts that they had that money, who their beneficiaries are, how much those beneficiaries received. the addresses of those beneficiaries. It is fully transparent so that anybody can come in and see exactly what's there. So if you had a child that you were trying to disinherit or you forgot about, they can come back in, creditors can come back in. So probate, bad at the end of the day. So when clients come in and say they need a last will and testament, that is why I say you may need it, but let's avoid it. And the reason that I say you may need it is because there are laws in place already that say even if you pass away and you didn't have a last will and testament, the law is going to distribute assets in a particular way. And if you are a nuclear family, meaning you are married to your spouse and you have children of that marriage, not children from a prior marriage, then the law automatically says if you pass away and we end up in probate court, then your spouse will automatically get your assets first and foremost. And if your spouse predeceases you, then your children will get those assets. And then if you have a child who predeceases you, that child's share, so if you have two children, say it's one child who passes away, one half of your estate would go to the grandchildren. So when most people call my office and say they need a last will and testament, at the end of the day, I say it's absolutely not necessary if you are that perfect nuclear family. The one caveat to that is if you have children that are out of state, they can't serve as your executor. It's called an administrator, and when you don't have a last will, but same thing. They can't serve as the administrator, which is typically not a big issue. You're already paying the lawyer 5% to take it through the process. You can pay the lawyer usually about another 1.5% to serve as the executor, and it basically is the same amount of money. So I wouldn't be too concerned if you have someone living out of state. You can still get the job done pretty efficiently as far as probate court's concerned. Okay, so with that, that is passing away and how your assets move from joint ownership to beneficiary designations to probate court if necessary. So Patty, again, to make sure I'm not missing anybody here, I'll take a quick break and see if there's any questions.
No one has typed anything in yet. Feel free to put any questions as he's going through in the chat box so we know we can address them. So, thank you,
All
Shane.
right, perfect. Absolutely. So it looks like we're doing really well on time. We're halfway through. The third box that we're going to talk about today is how we handle long-term care and other concerns related to people potentially making claims against your state and how we protect those assets. We already talked about this. This is just another summary again of what assets don't go through probate court, which is joint property here on the first one, PODs, second, anyone with a named beneficiary, which is the third icon, anyone with named beneficiaries, whether it be retirement accounts, life insurance, bank accounts, you name it. And then finally, anything with a TOD, which is again transfer on death designations like cars and houses. All right, so now let's go into trusts. There are two types of trusts at the highest level. There are probably hundreds of types of trusts when we go to deeper levels, but today I just want to help you give you an understanding and a basis for how trust works, especially as it relates to special needs planning that we're going to talk about a little bit later. At the highest level, there are two types of trusts, revocable and irrevocable. I'll help you understand exactly how those work. Let's see. I think I have a slide in here that is helpful. There we go. So, what I like to do to help people understand trust is I have an analogy. So, imagine that you go to the grocery store and you buy a bunch of groceries. You're with yourself, or you're by yourself, or with your spouse. And what I mean, you buy a bunch of groceries or all your assets that you currently have. So, everything that we've been talking about, bank accounts, life insurance, cars, houses, etc. You go to the grocery store and you put all those groceries into a plastic bag, or in this particular example, a canvas bag. And then you walk outside and you don't notice that proverbial bus coming by and you get hit by the bus. If you get hit by a bus and you're holding a bag of groceries, what happens to all of your groceries? They go everywhere, right? So that is essentially what we've talked about already. That's where your family comes to your house and they go, okay, mom and dad passed away. What are we going to do about trying to figure out where all their groceries have gone? And by groceries, again, I'm talking about your assets. So they go to your house and they go through all of your bank statements, they go through the mail, and they say maybe find 90% of what you have right there in your house through bank statements and otherwise. And they go through the same analysis that we went through earlier. Well, are we joint owners? And the answer is no, by the way. At least it should be. Never name a child as a joint owner on your bank account or anyone else other than your spouse. And the reasons are many. This is probably one of the hottest topics that I have that rip my clients' families apart when they pass away. It's because when people get older or they have individuals with special needs, they will typically become the joint owner on those bank accounts. And when you name someone as a joint owner on your account, you're doing a few things that you probably did not intend. And unfortunately, banks will tell you to do this all the time. When you name someone as a joint owner, you are making them truly a joint owner on your asset. So they have every right to go in and spend the money freely as they wish. If they develop mental health issues later on in life or substance abuse challenges, or they're just mad at mom and dad and they want to take that money and spend it or take it out of the account and do something else with it, they have every right to do so. So that's a big piece of it there. Additionally, when you name someone else as a joint owner on your bank accounts, you are introducing their liabilities. So if you have a situation where they're getting sued, like such as a legal liability, or they declare bankruptcy, or they're getting divorced, or they have issues where other people are potentially putting their pocket or their hand in their pocket, that means half of your assets are at risk of the bad actors that you have as joint owners. And the reason that it causes most strife is what people do not realize is, as we already talked about, if you name a child as a joint owner, say on a brokerage account with a couple $100,000 on it, when you pass away, that asset is automatically that joint owner's, and that child has no requirement to share that money, or that beneficiary has no requirement to share that money with anybody else. So, an unforeseen consequence a lot of times is that people pass hundreds of $1,000s on to their child, and that child doesn't share the money with other children, and we get a lot of family drama. So, all very good reasons why you should never name someone else as a joint owner on your bank accounts. Why I'm here, this is probably a good time also to mention that you shouldn't gift your house to a family member during your lifetime either. And I'll just take a moment to help you understand that risk. If you name a child, especially for a lot of my older clients, when they hit anywhere between 65 and 95 years old, they're like, hey, I'm just automatically going to give you my house so that we avoid all this probate stuff and it makes it super easy. When you do that, not only are you giving the house to them, and we have the same issues that we just talked about for the bank accounts, but what you're doing is you're really messing up your tax basis. And what I mean by that is whenever someone passes away and they're leaving assets to you through a joint ownership or through a beneficiary designation or through a trust, which we'll be talking about soon, then when you pass away, that asset that you're leaving to your family gets revalued on the date that you passed away. So if you have a house and you leave it to your children through a transfer on death affidavit or a last will and testament, then when you go to sell it, and say your parents bought a house for $15,000 in 1945. When you go to sell it and you are left as the beneficiary, you get it at the value on the date that they passed away. So if that $15,000 house was $300,000 on the day that they passed away, and you sell it for $300,000, you have to pay zero taxes. But if they gift it to you during your lifetime, meaning it's now in your name, if you go to sell that asset at any point, you lose that step up in basis. So all of a sudden you're paying capital gains, which is 20% on $185,000 simply because your parents were trying to avoid probate court and they didn't understand what they could do. So again, I highly, highly recommend that you do not have anyone gift a house during their lifetime, and you do something as easy as a TOD on the house to avoid that issue and keep that step up in basis. So a little bit of a sidetrack there. But anyway, going back to the last will and testament situation, the paper bag there. When your family collects everything together, they go through that same analysis. Are we joint owners? No. Are we beneficiaries? No. Did we go through probate court? Yes. And it could be any mix of those, right? Just to let you know, there's about right at $5 billion of unclaimed property in the state of Ohio right now. There's something called the Department of Unclaimed Funds, I believe is the appropriate name. That if your family left money out and those canned goods rolled away and people didn't realize that your parents still had bank accounts or insurance policies or other things, usually after 7 years, banks or whoever the custodian of that asset is required to escheat that asset to the state. And it's simply a legal word for giving it to the state to hold on to. You may have heard over the last year or so that they were looking to use the Department of Unclaimed Funds to build a stadium. I think it was for the Cleveland Browns or the Cavs or somebody. And I think it was just mentioned again here in Cincinnati to build another stadium. And to that, I would say you should be angry if you hear that because this is not the state's money. They're using the interest, which is great for government programs, but at the end of the day, this is the citizens' money, and you have a right to make a claim against those assets. You can go out right now and simply put in the person's name online and find out if there's assets that are available. Every time we deal, excuse me, every time we deal with a probate estate, we look it up. The challenge that you have with the Department of Unclaimed Funds is that in order to release that money, you have to go through the probate court because, again, there was no named beneficiary or they couldn't find them. And in order to get it released, you have to prove that you're the rightful owner. And unfortunately, it usually takes a minimum of $2,000 to open up the estate unless you do it yourself, which you can do in the state of Ohio. It's not necessarily easy, but you can. So what happens is you find a lot of assets out there that are anywhere from $1 to maybe eight or $900 quite frequently because the cost of getting it out of the Department of Unclaimed Funds to the probate court is just prohibitively expensive, which is why that those assets are sitting there. So the majority that's there was either because people don't know that they're there or because it was too expensive to pursue probate. So just be aware of that. Okay. So once we've gone through all that analysis, that is essentially what everyone's plan looks like today. If they don't have a trust, everything pays out in that way. Anything that doesn't pay out goes to probate. We're all very hopefully educated at this point on how that works. So what I'd like to do now is we're going to change it up a little bit, and instead of going to the grocery store and excuse me, putting everything in a plastic bag, we are going to put everything in an open cardboard box. And this open cardboard box we are going to call a revocable trust, as you can see on that image. When we talk about trusts, whether they're revocable or they're irrevocable, there are three primary responsibilities that you should be aware of. So the person who creates the box is someone called the grantor. You may have heard the word settler, but it's essentially the person who creates the box. So if it's your trust, you're creating that box. The next role is someone called a trustee. That's the person who's responsible for managing the assets that the grantor put into the box. With a revocable trust, which we'll get into the details here in a minute, you are not only the grantor, but you're also your trustee. So you're managing everything that you're putting in your own box. And then the third role is something called a beneficiary, which we've talked about that. That is who is benefiting from the assets that are being managed in the box by the trustee that were placed there by the grantor. So we go back to the grocery store. As you can see here, we put all of our assets in this box. You walk outside happy as a clam and you don't notice that bus coming by. When the bus comes by, instead of all of your assets going everywhere like they did in the plastic bag, what happens is all of your assets are contained in this box. The open box, which I'll explain in a minute, then drops down and becomes a locked box. And then you've named someone called a successor trustee, which is typically someone that you trust, a family member, a loved one, such as a child or a spouse. They have a theoretical key. They show up at the scene there, they unlock the box, and inside that box are all of your assets. So you don't have to worry about probate court if they're all properly in the box the way we anticipate. And the other important part of a revocable trust is it's all about contingency planning. And this is where special needs planning becomes very, very important. Most of my clients who have beneficiaries with special needs will, at a minimum, create these revocable trusts. Whereas when they pass away, the asset's locked in the trust, and there's particular language in there that says that the money in this trust or in this box should only be used for that child's health, education, maintenance. It's basically called ascertainable standards. And by having that particular language in there, if you have a beneficiary who's receiving government benefits, and this is a properly drafted trust, then they don't lose their benefits simply because they have an inheritance. This is really, really important to know. A lot of times, grandparents and other people will leave assets to beneficiaries with special needs. And if they receive that money, that is going to disrupt their government benefits in most situations. And the state will require them to spend down, they'll get kicked off their government benefits. They'll be required to spend that money down to essentially $2,000. And then once the money's gone, they'll get those government benefits back. So if you have a properly drafted revocable trust, then we know that that language is in there to create this special needs trust automatically, or what we call a supplemental needs trust, to protect those assets for the beneficiary so they not only get their government benefits, but they also get access to their inheritance at the same time. So it's a win-win. Uh, there are four types of really clients that I highly recommend have revocable trusts. First and foremost, anyone who has children or beneficiaries with special needs, kind of like we talked about before, if you name someone who's under 18 years old as a beneficiary on an asset and you pass away while they're still a minor, unfortunately, they will not get those assets directly. As we talked about earlier, those assets would have to go through the court. A guardian of the estate would have to be acquired, even if their parents are still alive. This guardianship has to be created. All the money has to flow through the court in that guardianship process. Accounting has to be done on a periodic basis. Anytime that money needs to be utilized, you have to request it through the court. The court grants the entry, and you take that entry to the bank to release the funds. And then at 18 years old, that money is released to that child no matter what's happening in their life. So having a child who's a minor or a beneficiary with special needs, always very, very important to at least have this revocable trust. And then also, it's a great way if you have other family members who are wanting to leave money to that individual to just leave it to the trust to make sure that that money's going in a way that's not going to disrupt their benefits. So that's children and people with special needs. Next is anyone who has a business. Quite honestly, a revocable trust can own 95% of businesses out there, even some professional businesses like dentist office to where if you pass away, it's automatic succession planning. So whoever that trustee is there, they can continue to manage the practice or hire other people or sell it or do what they need to do. So it's great succession planning. Third is any type of complex family dynamics. So think Brady Bunch. In this particular situation, you might have a late stage marriage where you want 90% of your assets to go back to your children and some portion to go to your new spouse. A revocable trust can make that happen in a way that's it's more appropriate than obviously the probate court. With probate court, we only talked about that nuclear family earlier. When you have a second marriage or children from other marriages, things get wonky and unintended consequences happen where the spouse who's living in the house and maybe have lived in that house for 30 years when you pass away, half that house now belongs to the children and half of it goes back to the other person who's on the title depending on how it works. So just know complex family dynamics, you should really talk to a lawyer to understand how those transitions happen. And then third, I would say anyone who has a questionable amount of wealth in a good way. And right now, believe it or not, I would say I don't get too concerned about needing a trust for large amounts of money until you approach probably around $10 million, which most people are like, wait, $10 million? I thought trusts were only for wealthy people. Well, as you can see, trusts are actually, I would say, more for non-wealthy people than for the wealthy people because right now, the reason that you would typically have trust for wealth is if you pass on more than $15,000 as an individual, or I'm sorry, 15 million or 30 million as a married couple, none of that is actually taxable. But as soon as you go over $15 million as an individual and giving from the moment you were born forevermore, then anything over that 15 million as a single or 30 million as a joint couple is taxed at basically 37.5%, which is really, really painful. So revocable trust is great for people who have wealth when you have quite a bit of money. So that is essentially a revocable trust. It accomplishes two things, probate avoidance and contingency planning. And again, that contingency planning goes above and beyond special needs planning. If you have a child who has substance abuse challenges, mental health challenges, divorces, bankruptcies, you name it, again, someone else has their hand in their pocket, then a properly drafted revocable trust would advise your trustee to make sure that when that money's going to the beneficiary, they're doing so in a safe manner that's not only protecting that beneficiary, but the assets of that beneficiary. So again, unfortunately, not all revocable trusts are created equally, and we highly recommend at least talking to a lawyer to understand what's right for you. And then finally, what I'd like to do, actually, maybe this is a good place, Patty, real quick too. I know we're down to about 15 minutes. I wanted to jump in and talk about irrevocable trust, but before I did that, I just wanted to shoot it out there and see if there's any questions yet.
Not so far. Um,
Okay,
so we're still good. Feel
perfect.
free to throw those questions in the chat box though, because I know you have some. So,
All right. Good. Thank you. All right. So the third and final trust that we're going to talk about today is an irrevocable trust. So we're going to go back to that grocery store one last time. And instead of putting everything in an open cardboard box, we're going to put everything in a locked blue mailbox. And let me go back real quick just to this revocable trust to help you understand the importance of the difference between the open box and the locked box. With this revocable trust, we talked about two benefits, right? We talked about probate avoidance and we talked about contingency planning. The box is open during your lifetime. And what that means is if you can stick your hand in and out of that box as the trustee or as the grantor to remove assets and do what you need to do, that means anybody else can stick their hands into that box as well. So we have zero asset protection with these revocable trusts during your lifetime if it's your trust. However, as we mentioned earlier, when you pass away and that box locks down in the street, then what that revocable trust does is upon your death, it becomes a locked blue mailbox, which means it is creating asset protection for your downstream beneficiaries. And this is a problem that we see on an ongoing basis where people created these trusts in the 1990s when the estate tax issues were around 380,000, not 15 million. And they were automatically assuming that because their assets were in these trusts, these assets were protected. And that is unfortunately just not the case. So if you have a revocable trust, you have no asset protection during your lifetime. And depending on the quality of the drafting of the trust, it does create some level of protection for your downstream beneficiaries after you pass. So, if we're looking at trying to create asset protection during your lifetime or your loved one's lifetime, which we'll talk about a little bit later about different types of trusts that are irrevocable, then we're really looking at this locked blue mailbox or the irrevocable trust. So we go back to the grocery store, and in this situation, if it's your trust, you are still the grantor, which means you're the one who's creating the box. However, instead of naming yourself as the trustee, you're now naming a loved one. So we're naming someone else or someone else that you trust. It doesn't have to be a loved one. A lot of people use corporate trustees, but you're naming someone else to manage that asset, and you're naming a separate beneficiary. So you're no longer your beneficiary during your lifetime, but your beneficiaries are your loved ones or other people that you want to receive that asset after you've passed away. So with this irrevocable trust, when during your lifetime, if you have issues where you have creditors or bankruptcies or legal liabilities, or in most of my clients' cases, when they're 65 or older, the majority of my clients will create these irrevocable trusts called a Medicaid Asset Protection Trust. Whereas when they put the assets in there, if they're in that box, that blue box there for at least 5 years, Medicaid cannot make a claim on the asset. We're going to talk a little bit about Medicaid today, but if you have concerns related to that or that's specific to you or your loved ones, feel free to give us a call and we'll go into the details a little bit later because it gets a little bit more complex. But generally speaking, what people don't realize is if they go into long-term care or they have beneficiaries that are receiving Medicaid benefits, depending on the types of benefits they're receiving, when they pass away, even though they've named all these beneficiaries on their accounts, the state can has the right to potentially come back and make claims against the property. So, for instance, if you have you have your own revocable trust and you're alive, again, the average cost of long-term care right now is about $12,000 per month. So men stay in long-term care on average about 24 months. Women stay in long-term care for about 36 months before they pass away. So you're usually looking at exposure between two and $400,000 on average if you go into long-term care. Federal statistics say that about 60% of people will go into long-term care at some point in their life. So basically the flip of a coin. But if we put assets into this trust at least 5 years before you go into long-term care, Medicaid can't touch it. So when we have clients that are coming to us because they're interested in estate planning at 65 and they own a house, the majority of the time we'll go ahead and create this Medicaid Asset Protection Trust automatically to protect the house from any future potential long-term care. So good. That is essentially how irrevocable trusts work. Again, you as the grantor cannot have access, nor can you have control of those assets. But a properly drafted trust would still allow you to essentially own, well, not completely own. The trust would own the house, but you would still have rights as the grantor to allow yourself to sell the house and buy another house later on if you need something that was more ADA compliant. It would allow your trustee to sell the house on your behalf and use those funds for you for independent living or anything else you needed. So I always tell my clients it's kind of like almost legally laundering the money through the trust because if it's done properly, then there's ways that you can protect your assets while still taking advantage of the assets that are in the trust. This is very complex planning. So again, I'd highly recommend that you talk to a lawyer if you are interested in these types of trusts. And then finally, what I do want to touch on today is special needs trusts and the types of different protections that are out there to preserve assets. When we're dealing with special needs trusts, there are a few that I like to highlight. You have something called a first party trust, where that is the money of the individual who is receiving those government benefits, where they create a trust for themselves. There's a lot of rules that I'm not going to go through today about when that's appropriate and when it's not appropriate. But there is ways that you can put money in these first party trusts to where you can qualify or stay qualified for Medicaid. Even if you receive an unexpected inheritance, these trusts can be created so that you don't lose those government benefits. In these first party trusts, usually under statute, Medicaid is the primary beneficiary before that money would go to other people, but it's a way of keeping benefits and still making sure you have the ability to use that inheritance during your lifetime. Another type of special needs trust that we use a lot are something called a third party trust. This is where it is not the individual with who's receiving government benefits assets, but it's the parents' assets or grandparents' assets or someone else's where they're creating a trust to protect the assets for the children or that loved one sometime later. So we were talking about earlier the revocable trust and having those supplemental needs trust contingencies built in. That's really what we're talking about here, is where you're leaving assets to your loved one who has special needs and receiving government benefits. By having it in a properly drafted special needs trust, it allows them to keep their benefits and still utilize the money that they received through an inheritance. And then the third, which I don't know, Patty, I'd like your thoughts on this. Is everyone pretty familiar with the stable accounts and all the great things that they offer for individuals today? Or should I touch on that a little bit?
If you can touch on that a little bit, we do have a presentation coming up in April, but some haven't heard that presentation as yet or may not be familiar with it. So there might be some here that um, aren't familiar with the stable account.
Okay, great. So the Ohio Able account, or it's called a stable account, is essentially an account that can be opened by the individual who's receiving government benefits, and it allows that money to be utilized for their benefit on an ongoing basis. It can be combined with their income that they're receiving, and generally speaking, it can have, I believe it's currently $19,000 a year deposited into that account, with a total, and don't quote me here, but I believe it's right around $100,000 per year with a maximum of $500,000. Again, wait for that presentation. But generally speaking, it's a great way to take money that is potentially could invalidate your benefits, put them into this account, and still be able to be utilized by the individual and keep their benefits. It's really a fantastic program. On that same piece, I would like to talk about pool trusts. The complexities related to being the trustee for these special needs trusts are really challenging to where if you spend the money in the wrong way, you could potentially lose government benefits with the way these trusts are offered. So when we're dealing with first party trusts and even some third party trusts, there are nonprofit companies called pool trust companies that will actually step in as a nonprofit and be the trustee on your behalf. Depending on which company you use, sometimes that you can leave beneficiaries to someone besides that pooled trust or to Medicaid. But in all circumstances, kind of like we talked, well, we haven't really talked about, but with the stable accounts, if something were to happen, that money, if someone were to pass away and had this stable account, the money first gets paid for final expenses, any type of debts that could potentially still be owed. And then Medicaid is primary and first in line for any distributions. And then if Medicaid's paid back, then that money would go back to the beneficiary. With these pooled trusts, whereas you're utilizing this third party nonprofit company, essentially it works the same way where you pay the final expenses. Medicaid is typically first in line, almost actually always first in line. And then, depending on the type of nonprofit or which nonprofit you use, sometimes only that pooled trust company is the beneficiary or that nonprofit. I believe the Community Fund Ohio is the only nonprofit pooled trust company that will allow you to name beneficiaries beyond Medicaid. So it pays final expenses, then it pays Medicaid, then it goes back to whoever you've named as the beneficiary on that account. So pooled trust is something we use quite a bit for smaller accounts that, again, kind of use the same way that these stable accounts are. If we have a large amount of money, so I would say 50, $60,000 plus, then we typically get into these first and third party trusts. But when we're dealing with smaller amounts, these free stable accounts to the state or these pooled trust companies can be great solutions to avoid losing benefits. Okay. So we have talked about a lot. There we are. There's the third party, first party, and stable accounts there. And I believe Patty will be making these slides available for you later on as well. Irrevocable trust, we talked a bit about that. So what's next? Just to let you know, all as you found out today through this presentation, that this can all be pretty complex and overwhelming. And this is all very specific to you. So I know there's a lot of do-it-yourself plans out there online that you can pay, $1,000 or whatever for these great comprehensive plans. But in the reality is these plans really working effectively for you. So one of the things that we do as part of the design for our law practice is we do not charge for initial consultations. As long as you're doing some work in the beginning to make it easier for us, we send out a questionnaire where we're asking about finances and family dynamics. Then we love to bring you in for a consultation where it typically lasts at least an hour, and we apply your facts to the law and help you understand what your plan looks like today and determining what, if any, documents that we've talked about throughout this presentation are appropriate for you. So we do these no cost complimentary consultations. You just give us a call, and Liz, who's our administrator, will kind of walk you through what that process looks like. Everything we do is flat fee. So during the consultation, once we understand what is best for you, we let you know the price up front. There is no ongoing fees for that. Once our clients become our clients, we also work a little bit differently than other law firms. We are never going to charge you above and beyond that fixed fee for anything related to managing your plan on an ongoing basis. So we actually kind of try to force our clients to come back every 3 years to make sure all their assets, if they have a trust, are in the box. Because if you don't properly fund your trust, meaning you don't have the trust named as either the owner or the beneficiary on your assets, your trust is just kind of an expensive paperweight. So even though we create our clients' trust, we want to make sure that they're being managed appropriately over the lifetime. And it's not, unfortunately, set it and forget it. It takes a little bit of work. So once you're our clients forever. The only time we charge going forward is if we have to put pen to paper for any type of changes. And with that, I will go to the final stage here that says when not to bargain shop. I know that the world's getting smarter with AI and all these different things, but I think we're still at a place now that it's really tough to make your own decisions because the world's complex and AI isn't quite there. So don't bargain shop with jumping out of airplanes and buying parachutes. With my father-in-law's situation where he had brain cancer, probably always great idea to get a second opinion with that. Any type of bank protection where we're dealing with money, and finally estate planning. So with that, Patty, I will say thank you very much again for the time today that you've given me to educate everyone. If anyone has questions, feel free to call our office. I'm more than happy to answer anything then and now.
Thank you, Shane. You had a lot of information there. I think I've written
Thank you.
about 4 or 5 pages. I don't know. So I will have some questions. So before we get into questions, I'm going to close the recording, so that, people can ask freely without feeling like they're being recorded. But again, thank you for your presentation. And I'll go ahead and close the recording for now. 1 second.